Passage 8. It needs to be observed for the purpose of correction and future guidance of the courts below that they ought to pay due respect and attention to the decisions of this court, which are cited by the parties in support of their submissions. Full stop. There should hardly be any need to keep on reminding them that the enunciation of law made by this court is binding upon them, and whenever a judgment of this court is cited before them, they are under a legal duty to deal it with due deference, after having carefully read it. Full stop. If the binding dicta applies to the facts of a case, then it has to be followed in the present cases, and this failure on their part amounts to refusal to do that which they are required by law to do. Full stop. It is not enough to mention a cited binding precedent in the judgment and then leave it at that. Full stop. Para. The manner of disposal of these cases has persuaded me to emphasize for the benefit of the courts below that dispensation of justice, according to Islamic tenets and concepts, is a solemn and sacred duty cast upon all Muslims by the Almighty Allah when dealing with the rights of the citizens. Full stop. It is, therefore, imperative that proceedings taken and orders passed by them must visibly show a keenness on their part to discover the truth. Full stop. How can justice be done or appear to be done if there be want of conciseness of this salutary requirement? Full stop. All jurisdictions are conferred, it reserved, for the discovery of truth, and only after much an honest effort has been made that it would be possible to render a fair and just decision in accordance with law, which governs the rights of the parties. Full stop. A slipshod or perfunctory disposal of civil suits amounts to complete negation of purpose of law and defeating the dictates of dispensation of justice in an Islamic state. Full stop. Para. On behalf of the respondents, a serious objection was taken to the competence of this court to interfere in revision with the exercise of discretion by the courts below, and for that purpose reliance has been placed on the decision of the Supreme Court in the case of Hadayatullah versus Murad Ali Khan. Full stop. I must observe, after having very respectfully read the judgment in the cited precedent of the Supreme Court, that the case under disposal does not fall in that category of cases where the courts below merely did not exercise their discretion in a proper manner under section 22 subsection 4 of the Punjab Preemption Act in extending time for depositing preemption money. Full stop. I have already enumerated the illegalities and material irregularities and wrong assumptions of law and fact, which led to failure of the courts below to lawfully and judi- judiciously exercise their jurisdiction, though discretionary full stop. The learned district judge was not even conscious of the nature of the power he was required to exercise, as is patent on the face of his impugned order. Full stop. He refused to exercise discretion in terms of irrelevant section 149 CRP